This is a recording by Dying with Dignity Victoria, Vice President Jane Morris, and me, President Hugh Sarjeant. We'll be putting this recording onto the website so you can look at it later if you happen to miss anything along the way. Jane will be doing the part on voluntary assisted dying, and so if you would find that part confronting in any way, you can just turn off when we start that process. Otherwise, we'll start by going through the topics we intend to cover and give an outline of how we proceed from there. So this is about, firstly, the background to Dying with Dignity Victoria. We'll cover understanding your legal rights, including the new laws. Advanced care planning, which is stipulating the treatments you will or will not accept at the end of your life. The appointment of a medical treatment decision maker who will carry out your wishes if you lose mental competency. And then we'll cover voluntary assisted dying, which will cover both the legal requirements and the process that you need to follow. And so now just a little bit about Dying with Dignity Victoria. We were established in 1974. We are heavily dependent on volunteers to help us, as we have only one paid employee. We played a crucial role in bringing the Medical Treatment Act in 1988, which allowed for the refusal of treatment provisions. We campaigned successfully for the Advanced Care Directive formalities in that Act of 2016, and we campaigned successfully for the Voluntary Assisted Dying Act of 2017. What do we do at the moment? You might think that with the voluntary assisted dying law having been passed, there's not much more to be done. But in fact, we see our primary purpose now is to ensure as far as we can that the law can be implemented successfully. We have interaction with the care navigators, who are government employees who assist in the process of the implementation of assisted dying. We have made submissions to the various committees of inquiry, largely now to do with the legislation for other states. We provide witnesses and sometimes contact people. These witnesses are required in the final stages of the search for someone for assisted dying, where they need to be able to establish that they are still competent to make decisions. We provide information such as in this recording now. We've been providing support for other states in their quest to get assisted dying legislation. We seek initiatives for the improvement in the process and in the content of the legislation. We provide the resources of information, and we offer a counselling service to assist people who may find information difficult to get. We'll be covering two laws. The first one is the one covered now by the Medical Treatment Planning Decisions Act of 2016. It came into effect March 2018, and it's intended to enable you to make a clear statement of what you do want to be available to you at the end of life, and perhaps more importantly, what you don't want. There are two parts to this. One is the preparation of an advanced care directive, which has an instructional part and a values part. We'll be coming to that later. And then also the appointment of a medical treatment decision maker. The next piece of legislation is the Voluntary Assisted Dying Act, which was passed in 2017. It came into effect in June 2019, and will provide a legislation overview of it and go through in some detail how the process works. You need to understand your legal rights. You've got a right to refuse or consent to medical treatment. This is all in general terms at the moment. We'll come into the details later. you obviously have a right to document your future medical treatment wishes, and that's covered in some forms which we'll provide information on also. You can appoint someone to act for you when you no longer have decision-making capacity, and you can also demand maximum relief of pain. Powers of attorney documents. The old documents are still valid. Those which were completed before March 2018 are valid today and don't need to be replaced, particularly the enduring power of attorney, financial, and enduring power of attorney for guardianship. But because of the new Act, Medical Treatment Planning and Decisions Act, it's preferable to update the two medical documents, which are the enduring power of medical attorney and the refusal of medical treatment forms, which relate to that new law. Advanced care planning covers the information on a plan that you need to make while you have capacity to make a plan, and which will be invoked if and only if you no longer can demonstrate mental capacity. You need to write an advanced care directive regarding instructions for your future care, and to appoint a medical treatment decision maker who ensures that those instructions are followed. We do recommend that you start conversations with your family, your friends, and your doctor. You need to let them know what you want, and importantly, what you do not want. Do be proactive. People often put these things off because they think, oh, we'll get around to it sometime. But circumstances can take over. Your advanced care directive comes into effect only if you have lost decision-making capacity. The instructional directive part determines under what circumstances you want the Act to apply, and there's a separate part for the treatment of dementia. The instructional directive is a legally binding document. It communicates your decisions directly to your health practitioners. You may consult a medical practitioner if you wish to complete this instructional directive. Again, it will only be used if you don't have decision-making capacity. Your medical decisions in this directive take effect as if you have consented to or refused them at the time in consideration of your medical treatment. If, however, it happens that any of the statements are unclear or uncertain in some circumstances, the values directive will then come into effect. For the advanced care directive, the first thing we do is decide the circumstances under which the directive will apply. For example, you may decide that it should not apply if you're suffering from some temporary loss of competence, such as, for example, when you've run low on blood sugar, or when you've had something called a transient ischemic attack, which resembles a stroke but is not. You may also decide that if, in fact, your severe illness, in the opinion of two medical practitioners, is likely to enable you to recover completely without psychological or physical suffering, you may decide that in that circumstance, you do not want your advanced care directive to apply. You then complete in detail particular matters which you may want to refuse or accept. And you say here, I declare that in respect of medical intervention aimed at prolonging or sustaining my life, I refuse or I would accept, for example, artificial respiration, blood transfusion, and so on. These ones are entirely at your discretion. You may decide that you accept or do not. And furthermore, of course, if you change your mind, you can always create a new advanced care directive. You may also note that any distressing symptoms are to be maximally palliated. In relation to dementia, you need to decide the conditions under which your advanced care directive will operate regarding dementia. For example, only if you've been admitted to institutional care, or regardless of whether you're at home, in the community or institution. You then need to decide under which conditions you will refuse medical treatment to prolong your life. It's important to make a decision about such things as whether you would accept assisted feeding. And in these regards, it is important to demonstrate mental competency often and as long as possible, to leave no doubt when you are capable of making such decisions. You do need to note that at present, dementia alone is not considered a valid reason to enable you to apply for voluntary assisted dying. And then to the detail in relation to treatment of dementia. If you've been diagnosed with dementia and judged by a doctor is not competent to make decisions, then you can decide again under the circumstances in which this would apply and what sorts of treatment you would or would not accept. We now come to the values part. The instructional part sets out, or is intended to set out clearly which you will and what want. But in some cases, that may be unclear. This values part is not legally binding and is intended to provide general guidance about your values and preferences. Our website provides some guidance for the completion of this part. It also covers organ donation, your medical treatment decision makers, and records of your appointment of those makers. Sample forms for these advanced care directives are available from several sites. There's one on the Dying with Dignity site. The Office of Public Advocate has forms. You can also get advice from the site of the Department of Health. These are formal documents. They need to be signed and witnessed. You need to sign. A registered medical practitioner witnesses and certifies, and another adult witness. If you happen to be completing these in the presence of your general practitioner, for example, it will often be that there's another adult available then to provide the alternative witness. These copies need to be available when they're needed, and so we suggest you make many copies of them. You can upload to your My Health record, and you can keep copies for distribution to your medical decision maker, your general practitioner, or his or her practice, and so on. You may wish to note also the protocol for voluntary refusal of food and fluid. This is an option which is available to you at any time, and it would result in death by dehydration. If you want to include this as an option in your advanced care directive, you should discuss it in detail with your medical treatment decision maker. Why is it important to have a medical treatment decision maker? The role of the decision maker is to see that your wishes and instructions are carried out. It may be that even if you've completed an advanced care directive, that there could be something which is unclear or ambiguous, and therefore you need someone you trust, someone who understands your wishes, someone who's got the ability to make medical treatment decisions on your behalf, to act for you at that time. You can appoint more than one person, but only one can speak on your behalf at any time. The role of your decision maker is constrained by whether you have an advanced care directive or not, and what forms that would take. And this form is set there for you to look at, really for completeness. Again, this is a legal process. The forms need to be signed and witnessed. 3 people are involved: you, a medical practitioner, and another adult person, any competent adult. The appointment needs to be accepted. The acceptance needs to be witnessed by another adult witness. And again, we suggest you keep many copies and upload to My Health Record as an example of where one of them should go. What happens if you don't appoint a medical treatment decision maker? If you don't, and if it reaches a stage where you've lost decision-making capacity, the person who will be involved will be one who is able and willing to act. The first choice would be your spouse or domestic partner, and then further on to your primary care or adult child, and so on. We now come to the part where we deal with voluntary assisted dying, and Vice President Jane Morris will speak to this part. And again, if you would find that part confronting, you could stop watching this presentation now.
Thanks, Hugh, and I'd like to welcome you to this online presentation in which I'm going to talk about voluntary assisted dying. The Victorian Voluntary Assisted Dying Bill was passed in November in 2017, and after an 18-month implementation process came into effect in Victoria on June the 19th, 2019. It was an historic piece of legislation in as much as Victoria was the first state to pass this law. Since then, we've seen legislation pass in Western Australia in 2019, Tasmania earlier this year, and more recently, South Australia. This piece of legislation allows a person with decision-making capacity, a terminal illness, and what they consider to be intolerable suffering to make a request for a doctor to help them end their life by the self-administration of medication. In some circumstances, a patient may not be able to administer the medication, and I am talking perhaps about someone with motor neuron disease who physically can't get the cup of water to swallow, or perhaps they've lost the ability to swallow, and there are other people who have gastrointestinal problems where the medication is unable to be absorbed. And in this case, a doctor can admit the medication via an IV cannula. The request must be made enduring and not made under duress. It's a complex piece of legislation. There are 68 safeguards in it, 143 clauses, and 8 statutory forms. And in fact, when it was passed, it was said to be the most conservative legislation of its type in the world. Many people were actually critical of the bill and said that the eligibility criteria were too stringent and that this would mean that people would be deemed ineligible to access VAD. Before I go on, I just want to stress one point, that anyone who accesses the Voluntary Assisted Dying Act must be deemed competent, unlike what Hugh has spoken about, where you can appoint a decision maker on your behalf if you no longer can make decisions. Anyone applying for voluntary assisted dying must be fully competent. Right, one of the problems we found with the legislation, and it has been quite controversial, is the fact that a doctor cannot initiate the subject of voluntary assisted dying with you. The person themselves must initiate the request. So for example, if you were diagnosed with a terminal illness and you go to your doctor and ask what sort of options, he can suggest things, other forms of medical treatment, he can suggest palliative care, he may suggest the right to refuse treatment and even to refuse food and fluids, but he cannot mention the option of voluntary assisted dying. Even if you're referred to an oncologist, he could mention chemotherapy, radiotherapy, but again, he cannot bring up the topic of voluntary assisted dying. It is only after you've raised the topic that it can be discussed, as with other treatment options we've listed. Voluntary assisted dying, the definition. Within the Act, it is described as a disease, illness, or medical condition that is expected to cause death within weeks or months, but not exceeding 6 months, except in the case of neurodegenerative illnesses such as motor neuron disease, MS, Parkinson's, where a 12-month period for prognosis has been given. It also must be associated with an advanced, incurable, and progressive illness. And most importantly, one in which the person deems the suffering to be intolerable and that their pain can't be relieved in a manner that they consider tolerable. Therefore, the person is the judge of this suffering, not the doctor. So once again, I give an example of a doctor might have 2 different people, both with the same diagnosis, both at similar stages of the progression of their disease. One might find that their pain is well and truly alleviated by a couple of Panadol each day, and the other may require strict 4-hourly doses of morphine. The other thing is intolerable suffering is not always just associated with physical pain. You can suffer from what is called existential pain, and this includes the feelings suffered from the loss of autonomy, that is the lack of dependence, the lack of independence, and this may be exacerbated by the inability to complete everyday tasks such as washing and toileting, and the loss of any feelings of pleasure. Simply, life lacks meaning, and there is no joy found by simply existing. Many people think that simply having a beating heart is not considered to be indicative of a life worth living. So the voluntary assisted dying process. The person must make 3 requests for voluntary assisted dying over no less than 10 days. Initially, they make a verbal request and then a written request. And this written request is done in the presence of 2 witnesses. The witnesses are required to assert whether the person is competent, whether they understand the process and the implications of taking the medication, and also to ensure that the person is not being coerced. Only one witness can be a family member, and neither witness can be the beneficiary of a will, be directly involved in providing healthcare services to that person, or be responsible for the running of a healthcare facility in which the person resides in. Dying with Dignity Victoria has been providing witnesses, and it has been a very, very successful venture for us. 2 medical practitioners, and then finally a second verbal request. 2 medical practitioners independently certify the eligibility of the person. Both practitioners are to be fellows of a medical college, and one of the practitioners must have experience and expertise in the disease of the person. Now, this has also proved to be quite problematic, especially for people living in rural areas. Once again, if you had a patient with motor neuron disease and they need to see a neurologist, not only do they need to see a neurologist, they need to see a neurologist who has the relevant expertise in motor neuron disease. We can't expect specialists from the city to be doing trips to rural areas to visit their patients. This would be far too time consuming. So unfortunately, many patients who have been bedridden in severe pain have been forced to come down to see a specialist in the city. I have put down the bottom actually of this slide and the next one, the person can opt out at any stage. And this is very, very important because every single stage of the voluntary assisted dying process, the person has the ability to say, no, I don't want to go any further with this, even up to the stage where they're about to ingest the medication. At each stage of the VAD process, medical practitioners will complete the relevant paperwork, which they'll then submit to the Voluntary Assisted Dying Review Board before progressing to the next stage. After all the stages have been completed, the medical practitioner seeks permission from the health department to prescribe the medication. Pharmacists at the statewide pharmacy, which is located at the Alfred Hospital, receive the script, and 2 pharmacists will deliver the medication to the person when requested and explain the process. This is a wonderful service because the pharmacists will travel all over Victoria, and they will spend as much time as possible explaining the process to not only the person, but any family members that happen to be there. And I've heard of visits that have lasted for over 2 hours, and people have been really, really grateful for the help they've provided. And once again, the person can opt out at any single stage. The Voluntary Assisted Dying Statewide Care Navigators. They probably have been the backbone of the whole process. Any hiccups, difficulties that anyone in the whole process experiences, they all seem to be referred back to the navigators, and they seem to be able to resolve all problems. They are a key support for anyone across Victoria seeking information about voluntary assisted dying. You can ring them, email them, and they'll respond to you. They can also advise you about getting a support package. People living in rural areas, especially if, as I said before, they need to visit a specialist in the city, they can be provided with a package for that. They also provide health service education, and there are 3 of the care navigators located at the Peter Mac Hospital, and a couple now are scattered through regional Victoria. As you can see, the process does take some time. And if you're considering voluntary assisted dying, you need to do your research and you need to plan very, very early. I'm going to go into this in a bit more detail, but you need to identify doctors who will help you with the process and also who have done the required training. We also recommend that you discuss this with family, friends and carers, but at the same time, we're very mindful that not everyone wants to inform their family and friends about their decision to access VAD, and their wishes for privacy must be respected. Right, prepare early. And this is why we need to prepare early. Quite a bit of documentation is required to provide proof of residency and age. So first of all, you need proof of being over the age of 18 years. This can be provided by one of the following, either a medical record, birth certificate, or a Victorian driver's license. The second is an Australian citizen or permanent residency certificate, and this can be provided by an Australian birth certificate if born between August 1986, a passport that establishes Australian citizenship, permanent resident visa, or a permanent resident visa grant number. The other thing that you also have to prove is that you are normally resident in Victoria for at least the last 12 months. And for this, you need to produce a Victorian driver's license or vehicle registration, registration on the Victorian electoral roll, medical record showing your Victorian residential address, or a lease document or a utility bill. But again, just one of those. An example of how important this is there was a case of a man who was very ill with cancer, and he was so relieved to find a GP who agreed to help him with the VAD process. The paperwork was handed in, he ticked all the eligibility boxes, except he didn't qualify for the residential eligibility requirements. He'd spent many, many years living in Australia, but hadn't sought permanent residency. He was deemed ineligible for voluntary assisted dying because of this one factor. But unfortunately, he was so ill that he didn't have the energy to start the process again. So he took his own life under horrific circumstances. This was a hideous way for this man to end his life, and it was also devastating for the GP who had helped him. So I urge you to get those certificates and put them somewhere so that you can always, have them on hand and get them if ever you need to quickly. Not everyone will find the process of accessing the legislation easy. What we do suggest at DWDV is that when you see your doctor next, ask him, if I were eligible under the Voluntary Assisted Dying Act, would you support me if I wanted to use the process? If the doctor says yes, ask them if they have done the required specialist training. The required specialist training is a 6-hour online course. If no, you can contact the statewide Voluntary Assisted Dying Navigators for assistance, and I will talk a little bit more about that in a minute. Dr. Rodney Syme, who everyone knows, I'm sure, has kindly offered personalised support and counselling for those that need it, and his details are below there. I heard recently about a person who'd been diagnosed with a terminal illness and went to their GP of 35 years. The GP refused to discuss the issue of voluntary assisted dying. So we recommend you don't be intimidated, even if your doctor provides his own personal opinion of VAD, which he opposes, and may not refer you to another doctor who would help you. Reach out, there is help there, and there is advice that can be provided to you. We need more doctors. As we've seen in other countries, when assisted dying legislation is implemented, there's often not really a lot of doctors that put up their hands. They like to stand back, see how the process works, and then as time goes on, more and more register. Dying with Dignity Victoria would like to know which doctors do support VAD, and we are making a highly confidential list of supportive doctors who've done the training, and this is compiled and accessed only by Dr. Rodney Syme. So as we said before, ask your GP or your specialist if they support VAD, if they've done the training, and if they say yes to both, ask them if they're happy to have their names put on our list. Then if you let us know whether your doctor is supportive, we can add them to the list. So you helping us, we can then help you. How's it going? Look, it's going really, really well. The reports from the Supervisory Voluntary Assisted Dying Review Board are constantly positive. And one of the main worries, concerns a lot of people had, the opposition voices regularly, is that elderly people will be coerced into going down the voluntary assisted dying path. However, the former Supreme Court Judge Betty King, who's the chair of the review board, stated a few months ago, "I have not seen one example so far of anyone who has been pushed, coerced, or inveigled in any way into taking the assisted dying medication." An oncologist, Cameron McLaren, who's been involved in many, many cases of voluntary assisted dying, has observed the following. He stated the atmosphere has been very peaceful. It's been a real moment of closure for the families to say goodbye. And he's also added that he's still surprised by how he's never seen a person flinch about picking up or taking the drink. They're so committed to it. It is going well. However, I have mentioned two issues that have been problematic, and that is the fact that the doctors can't initiate the topic of voluntary assisted dying, and that we do have too few specialists in rural areas. Another thing that has proved to be very problematic is the inequity of access for all Victorians to the process. There is an overriding federal law that prevents doctors from discussing voluntary assisted dying via telehealth, whether this is over a phone or any other electronic carriage service. This means that many patients must travel to see their doctors, and this may mean travelling vast distances when they're in great pain and often attached to numerous items of medical equipment. Some people might be bedridden. So it's asking really an impossible task for many people. And I think the lockdowns we've had recently in COVID have absolutely exemplified the major problem here, because people have relied on telehealth for many, many other aspects of their health care. And it seems wrong that people, dying people, haven't been able to avail themselves of this opportunity. One other thing, which I will just add in, is Dying with Dignity is in the process of setting up a support group for family and friends of those who have died using voluntary assisted dying. Many people are reluctant to talk about their experience with friends and even with other family members. And some people don't even have anyone to talk to. This group aims to put people in touch with other people who have shared the same experience. It's not a counselling group, it's simply a discussion and support group. If you know someone who would benefit from this service, please tell them to contact our office. So just to recap from today's presentation, it is so important to have conversations about your end of life choices with family, friends, your doctor. We recommend you appoint your medical treatment decision maker and complete your advanced care directive. Make lots and lots of copies of these documents, which will then be downloaded. Some can be downloaded onto My Health Record. Give it to your doctors, give it to your aged care facilities, families, friends, your medical treatment decision maker. I've even heard of people who have been really sick at home and they've stuck copies on the front door, just in case the ambulance have to break in. Everything's there, easy to access and easy to enact upon. And please support Dying with Dignity Victoria. We're made up almost entirely of volunteers. You can become a member. You can donate. Any donations are tax deductible. You can leave a bequest if you'd like. And volunteers. So many people have different skills, and if you feel that you could contribute in some way, please contact us and we'd love to hear from you and see if you can help us. There's still so much to be done to ensure people can have a dignified death, and we are there to help people and ensure that this happens. Thank you very much.
So that then completes our presentation. We'll be putting this presentation on the web to be accessed at other people's convenience. We also offer these presentations to groups where we can provide feedback, we can respond to questions, and also provide handouts. We hope you found this presentation useful, and if you have any concerns, do get in touch with us.